Hello everyone, I'm Celia Becker, an executive in the Africa Regulatory and Business Intelligence Department at ENS Africa, and I'm pleased to welcome you to the first of our Investing in Africa webinars. This will be one of many conversations featuring a multidisciplinary team of experts across multiple jurisdictions on the continent, where together we will discuss how to navigate the complexities of investing in Africa. Today's session is focused on strategies to protect and enforce intellectual property rights, and I'm joined by a panel of IP experts who offer the full spectrum of IP services across Africa. Gaelyn Scott heads the firm's IP team and is a specialist trademark litigator with 25 years of experience enforcing clients' IP rights across Africa. Gaelyn is consistently ranked as one of the top 3 trademark litigators in South Africa and has recently been ranked as South Africa's top IP practitioner. Ilse du Plessis is the co-leader of the trademark prosecution team, and over her many years of practice has achieved recognition by various international ranking agencies. Her experience includes all matters concerned with trademark portfolio management, including across the African continent, where she assists clients in various industries with trademark filing strategies and projects. Dr. Joanne van Harmelen is one of the most highly qualified and experienced life sciences patent attorneys on the African continent and heads up ENS Africa's IP life sciences practice. She works with large multinational companies to provide global patent strategic and filing services, including across the African continent. She also works with many universities and startups, providing hands-on support for innovative and cost-effective ways of identifying and protecting IP. Waldo Steyn is the head of the commercial IP team, and his practice focuses on supporting clients to recognize the role and value of IP in the organizations, ranging from employment and consultancy arrangement due diligences, M&As, intra-group IP management, and the structuring of the holding and use of IP assets in international groups. E&S Africa was recently awarded the Managing IP Transactions and Advisory Firm of the Year for South Africa based on the work of Waldo and his team. Welcome to all of you, and we look forward to the discussion. To all our attendees, please feel free to post any questions that you may have in the Q&A box, and we will address them at the end of the session if time allows, otherwise afterwards. Waldo, over to you.
Celia, thank you very much. I think by way of introduction, I would like to make a few comments to just kind of set the scene for the discussion today. And a good place to start is with some work done by the African Development Bank. So according to the African Development Bank, Africa's growth in real GDP was estimated at around 3.8% in 2022. This was down from 4.8% in 2021, but above the global average of 3.4%. The growth slowdown was attributed mainly to tightening global financial conditions and supply chain disruptions made worse by the Russian invasion of Ukraine. Growth was also impaired by the residual effects of COVID-19 and the growing impact of climate change and extreme weather events. While the growth deceleration was broad-based, with 31 of the 54 African countries posting weaker growth rates in 2022 relative to 2021, the continent performed better than most world regions in 2022. In fact, the continent's resilience is projected to put 5 of the 6 pre-pandemic top-performing economies, and those are Benin, the Ivory Coast, Ethiopia, Rwanda, and Tanzania, back in the league of the world's fastest growing economies in 2023-2024. And remember, Egypt's already right up there. According to the African report, Sub-Saharan Africa, with a projected growth of about 3.5%, appears to be doing better than other regions, except for Asia. The African report specifically highlights Senegal, Niger, the DRC, and Rwanda as countries with high economic growth forecasts for 2023. So to focus a little bit on that, Senegal is topping this ranking with a growth forecast of more than 8.1% for this year. And that's thanks to its hydrocarbon sector. That's followed by Niger with a sort of forecast of more than 7.3%, largely due to the development of agriculture, public infrastructure investment, an increase in foreign direct investment. But that forecast, you would kind of think, will probably have to be adjusted following the political developments there over the last 48 hours. Then in third place, sort of the DRC and Rwanda, tied with a forecasted growth rate of more than 6.5% for this year. And in the case of DRC, that growth is expected to come from mining and sort of advances in transport and infrastructure. The African Development Bank's outlook for Africa remains positive and stable, with a projected growth rebounding to about 4% in the current year and 4.3% next year. Its projections, and this is really important, shows that 18 African countries will experience growth rates higher than 5% in 2023. And that number of countries will grow to 22 next year. So that means by 2024, the African Development Bank estimates that 22 countries in Africa will have an economic growth rate of more than 5%. So foreign direct investment in Africa sort of hit a record $83 billion in 2021. And that was due to, or according to a report by UNCTAD, sort of that was published last year. And this was more than double the amount reported in 2022. So that's quite important. There's definitely a trend here. The African Development Bank highlights a number of sectors as offering investment opportunities. So if we think sectors, these would be agriculture, energy, mining, health infrastructure, the pharmaceutical industries, light manufacturing, transport and logistics, and the digital economy. So quite a number of sectors on the radar there. Against this background of investment in Africa, it's important to understand the relative importance of intellectual property assets to companies and their economic activities. According to research conducted by Ocean Tomo, intangible assets like intellectual property rights associated with inventions and brands accounts for 90% of the value of the S&P 500 companies. To put this into perspective, the research reveals that in the mid-1970s, that was only about 17%. There can be no doubt that intangible assets, and in particular intellectual property, is not only highly valuable as an asset class, but the most significant driver of value and value creation for companies. So against this background, what we want to talk about today is intellectual property, and in particular, the protection and enforcement of these assets in Africa. So Ilse, I'm going to sort of focus on you first, and I've got a few questions that I hope we can run through. The first one is, if a company or a business would like to protect their trademarks in a number of African countries, how would you typically advise them to go about it?
Thank you, Waldo. I think let me start off by saying that we really prefer to create a proper filing strategy for clients who are either entering the African market or maybe simply expanding their operations on the continent. When we do so, there are several factors that we take into consideration. First of all, in addition to the normal budget considerations that are obviously very important, there are often industry-specific factors that we take into account. Just to give you an example, a client in the fast-moving consumer goods industry, for them it's usually very important to understand the main distribution channels into Africa. And with that also, for instance, where the big and large supermarket chains are located. This is where the goods are going to end up and where trademark protection should obviously be sought. Other factors that we typically look at is, for instance, the so-called first-to-file countries. Now, these are the countries where trademark protection works on a kind of a first-come, first-served basis. And there, your trademark protection should obviously be prioritized. Then, and Gaelyn will maybe talk about this later on, clients should be aware of where the counterfeit hotspots are. For instance, if they're only operating in a landlocked country, such as Ethiopia or Zambia or Uganda, it's important for them to know where the goods will be entering, the ports of entry. We will also take into consideration where trademark enforcement or litigation is protracted or maybe costly. And those are the kind of factors that, we need to package and then decide on how to take it further. So assuming that we've looked at all these factors and we've now identified the relevant countries and we've prioritized them, we will then look at the filing systems that can be used to achieve both effective and valid trademark protection in Africa.
Ilse, sort of two questions in one go. Can I just check with you, do I understand correctly that with the landlocked countries, you actually want to make sure you've got protection in transshipment kind of countries or where they would come through as well? Is that why you look at it in that way?
Absolutely. It's important so that you can stop them at the relevant ports where the counterfeits come in.
That's an important strategic step there. So Ilse, you mentioned filing systems. How does that work? What different systems are available in Africa?
So Waldo, there are basically three options that you can use. Firstly, one can simply file national applications in the relevant trademark offices. For me, and I think for most of my colleagues will agree with me, that's still the gold standard. Do national filings, that's the safest, most effective route. But there is a second option that not everybody knows of. And with that option, you can secure trademark protection in African member countries of a system that's called the International Registration System, also known as the Madrid system for us in the industry, and more about this later. The third option is to use one or both of the two regional filing systems that we have in Africa, also known as OAPI and ARIPO, again, industry terms, but that's what they are called. And in a nutshell, a single OAPI application will give you protection in 17 French-speaking, let's call it that, countries in West Africa, whereas an ARIPO application can give you protection in up to 13, let's call it English-speaking or Anglophone countries in Africa. Does that answer your question?
It does, Ilse, but it sounds a bit like a teaser in the sense that sort of you mentioned these systems, and I think sort of we'd like to sort of unpack them a little bit better to understand what differences or nuances do they offer a company that wants to protect its trademarks in Africa. So maybe if we start with the national registrations, sort of, can you maybe just share a bit more information around that?
Yes, sure. I mean, time permitting, I can keep you occupied for quite a while, but just as a general observation, we often find that clients are a bit hesitant to file in certain African countries. Now, really the good news is that there's been significant developments on the trademark front, really across Africa. And I think I can safely say that most African countries, the systems applicable there are much more in line with developed nations than it was before. To just give you an example, in Malawi, for instance, recently passed a bill that's modernized their trademark system. Yeah, again, I don't want to become too technical, but you can now, after many, many years of not being able to register your trademarks in respective services, that is now possible. And was very good news for companies, you know, for instance, in the financial industry services, who had to very artificially describe their services in terms of goods, which you can imagine is a little bit ridiculous. So now they can get proper protection in Malawi. But there are various other countries that have also modernized their very antiquated laws, like Ethiopia, Namibia, Mauritius very recently, Mozambique, and even Somalia have, you know, introduced new legislation. There are a couple of countries in Africa that now and again, you know, where the registries close and you can't really process applications. But it really depends on the political situation. So just for obvious reasons, Sudan at the moment is a country where the trademark registry is closed, but Libya is open for business again, at least for the time being. And you can do trademark reservations again in South Sudan. That's a very fresh development. So the bottom line is, yes, with national protections, national filings, you can really get fairly effective protection across Africa these days. Any other questions?
Ilse, you mentioned an international system, and often when I speak to clients, there is this, almost want to say, sort of this idea that this international system allows you to file one trademark and you're covered everywhere and maybe the moon as well. And I remember sort of in a previous life doing work for a big airline in the UAE, and who someone there decided they want to protect their trademark everywhere in the world. And when it came to the cost of that, was really upset about what was happening. So it wasn't with ENS, so just let the audience know. But this idea of a single trademark and you can protect it anywhere, is that what this international systems allow, or system would allow us? Or can you maybe share a little bit more how that would work, and specifically in Africa?
Yeah, absolutely, Waldo. And Amanda, can you maybe just put up the first map? There you are. So yes, the Madrid system is an international system for obtaining trademark protection in a number of countries and regions using literally a single application. So protection, that's also known as the international registration, can only be obtained in countries and regions that have joined the system. So this map that we've got up on the screen shows the 40 participating African countries. They're all indicated in brown on this map. So in theory, Waldo, the system may therefore sound like the simplest solution to obtain protection in the majority of Africa. There are certain key requirements that really need to be met before this system can be used effectively. First of all, there should be national trademark laws that recognize the validity and enforceability of international registrations. There should be regulations that guide both the office and users as to how this process works. On a very practical level, the IP officers, the registries, should be trained and know how to process these designations. And then again, quite practically, there should be one trademark register so that somebody who wants to know what's on the register should see both national and international registrations. Now, yeah, the bad news at the moment is that really only a handful of countries in Africa do meet the key requirements, and so we typically still suggest that clients, rather than using the Madrid system in Africa, still rather file national applications or use one of the two regional systems, with one or two exceptions. Oh yes, I actually just wanted to mention something else. It's quite important here is some of the largest economies in Africa have also not yet joined this particular system. For instance, Ethiopia, Nigeria, and South Africa. And just from the point of view of creating a filing strategy and looking at budgets, that might just put you off using this system at this stage for Africa.
Ilse, can I maybe just check with you? So my understanding is that with this system, you file indeed a single application, but you still have to designate. So choose the countries where you want, or the member countries of this network or treaty, to then extend that protection to. Is that how it would work then in Africa as well?
Absolutely. Again, you can designate all African member countries. In theory, get protection in 40 Africa countries. The problem, however, and I won't go into those key requirements again, is that most countries in Africa do not meet those requirements. And even if you designate them, you might not end up with a valid registration.
Thank you, Ilse. So that was the second of the different systems that you mentioned. You also mentioned the regional systems. And I know that sort of the UAPI system, for example, seems to be very effective. And I'm only mentioning that because I've sort of long ago used to do sort of work in that environment. But sort of, can you tell us a little bit more about UAPI and ERIPO and how these regional systems work?
Sure. If I can get the next slide, the two maps, thank you. So just to recap, as far as ERIPO is concerned, you can file a single application at the ERIPO office. It's currently situated in Zimbabwe, and that can cover up to 13 countries. They are all shown in purple on this map. Again, not all good news, because with the exception of 6 countries, none of these member countries have amended their national legislation to domesticate ERIPO. And even where they have done so, there is still a lack of cohesive procedures, to properly process these applications. So we use ERIPO, and we're quite confident that it will give you a valid registration in a number of countries, but definitely not in all of them. Then going on to OAPI, those are the countries reflected in green on the screen. OAPI, as I mentioned previously, is a union of 17 predominantly former French protectorates who have established like common law, common IP laws, and they work through a single office in Cameroon. The 17 member countries, as I said, are shown in green on the screen, and I can really say that OAPI functions very well and provides a cost-effective way to obtain trademark protection in all of these countries.
Can I maybe just check with you? So in the Madrid system, I file a single application and I choose countries. Can I just double check, and maybe I wasn't listening carefully enough, but sort of, does OAPI and a repo provide me with that same flexibility, or how would those two compare to each other?
Yeah, only OAPI provides you with flexibility insofar as you can designate any number of member countries. OAPI is one size fits all. You file an OAPI application and you automatically cover all 17 member countries, very much like a European Union trademark application.
So one would be able to look at a repo then and say, okay, I only want 2 or 3 countries in the repo system, but when I go to OAPI, I automatically get the 17 sort of the protection in the 17 countries for my single application, basically.
Correct.
Okay.
Very cost effective, and the system works very well.
Now, from that last bit of our discussion, it seems already that one may want to use at least a repo and OAPI maybe together at the same time because they cover different countries. How are you advising clients, or can one sort of, when you look at the strategy, start using these different systems together?
Absolutely, we often have to do that. I'm happy to say that over the years we've guided many clients with expansion plans in Africa to find filing strategies that suit their particular needs and, of course, their budgets. This includes, for instance, a very large international hotel chain that we've done this for, a COVID vaccine producer, a mass media company, various financial institutions, etc., all really expanding aggressively into Africa. And we had to advise them, how do you go about this in a cost-effective way, but that will also give you effective trademark protection? Amanda, can you just put up the further slide? So if you look at this map, what I've tried to do here is just to show you how you can combine national filings with the 2 regional systems, and also the international filing system Madrid, in order to give you coverage really across Africa. If you look at the countries indicated in brown, and there are really only 4 of them, those are the countries where we are comfortable suggesting that clients use the international registration system to designate countries. The countries in green, as I indicated previously, OAPI, 17 countries, you can use the system there. In fact, you don't have a choice. If you want to cover those countries, you have to use OAPI. The countries in purple are the ones where, and it's only 6 of them that we're comfortable telling you to designate countries under the repo system. And for the rest, really, those are national applications that we suggest clients use if they want effective protection in Africa. Thank you, Waldo.
No, thank you, Ilse. I mean, I think that was quite insightful to see the kind of things that one need to think about when you think about protecting your trademarks in Africa from a filing strategy point of view. I'm particularly interested in the fact that you've got to look at your route to market from a supply chain sort of point of view. For example, goods moving sort of through a one port into another country, something that might easily be overlooked. And I think it's critically important that our clients and investors know that you've got to carefully analyze and understand whether it's the Madrid system or the repo system for trademark filing, and to make sure that you get proper advice on where the investment in the trademark protection can then be enforced. Because if you go to a system that doesn't have the required national implementing legislation and systems in place, you may end up spending money and not actually getting any bang for your buck, so to speak. So Ilse, thank you. That was, I think, very, very insightful. I would like to move on to a different box or category of intellectual property. So I think we've seen there's a great system for protecting trademarks, but for me, always the really cerebral, the really sort of heart of intellectual property, one quite often thinks sits in patents. And Joe, I'm not only saying that because you're a doctor, I'm saying that because that seems to be where this whole idea of providing or granting a monopoly around intellectual property comes from. So Joe, we've heard from Ilse quite a bit about protection strategies and how we can protect in Africa, talking about trademarks. Can you tell us a bit more about the landscape from a patent point of view?
Sure. I mean, I'm quite fortunate actually, because Ilse has provided me with a fantastic base to kind of comment from. So as in the case of trademarks, there are the same two regional systems for patent filing in Africa. We've got the ORP and the EURIPO systems, and in exactly the same way, ORP filings cover automatically all 17 countries. In EURIPO, there are, however, some advantages on the patent side, which you don't have on the trademark side, in that Ilse had said only about 6 of the countries were properly kind of effective in respect of trademark filings. But for patent systems, there are far more member states of the EURIPO treaty that have effectively acceded to the treaty and have actually implemented local legislation so that you can have effective filings. So if you can show the slide, you'll be able to see. So this is a slide for EURIPO and ORP patents on the continent. You can see in orange this time, the ORP countries. And as you can see in dark gray, these are the EURIPO countries which you can designate when you do a filing. It's a system where you have a little bit more flexibility than ORP, in that you can choose which member countries you would like to designate in. So if you want a really nice broad spread across the continent, you could choose to file an ORP application and you'd get 17 states. And you could choose to file an EURIPO application, and you could then choose each of the 20 member states where you can effectively file an EURIPO application. And that obviously gives you a nice big spread across the continent. You've got 37 out of the 54 countries covered if you do that. However, you might not necessarily be interested in all of the EURIPO countries, and the flexibility there is that you can choose any one or more of those countries to designate when you file your application. From a cost perspective, you will pay per state for filing and for maintenance fees. So obviously, if it's a cost issue, you could select the states that are most important. But it may also just be a commercial choice where you're not interested in every single state. And then obviously incurring those costs isn't worth your while. The thing that is important to note also, though, is there's added flexibility at EURIPO in that after you have filed your application, you also have the opportunity to request to add additional states or to remove any states that you're not interested in. You will pay some additional fees, but it is a useful extra flexibility.
Joe, so having been in consultations with you often and often talking about sort of the Patent Cooperation Treaty, I know that you quite often advise clients on the strategic side of it and say, listen, you've got time to make a decision. You file a PCT application, and then you've got, I think it's 18 months, can be extended to select the countries or the territories where you want to go to. How does EURIPO work as far as, let's say I file a single application and then I have time to choose the countries? What window of opportunity from a finance point of view or getting the right sort of backing to be able to expand my portfolio, what timelines are we looking at there?
So if you had to look at a PCT or an international filing, as you mentioned, that gives you, as you said, in fact, in the case of EURIPO, you've got an additional 19 months to file your EURIPO application. Once you file your EURIPO application, at that time, you obviously need to choose which countries you're interested to go into. So you may choose, for example, 5 countries to start off with and pay the filing fees for designating those 5 countries. But if you then down the line discover that actually there are additional countries that are of interest, any time before grant of that ARIPO application, you can make an application to add additional countries to that application. On the converse, if you had chosen all 20 countries, and then you discovered that actually there were some countries that were really no longer of interest, and you didn't want to go on and be incurring the annual renewal fees for those countries that are not of interest, you can abandon those countries. And so you can likewise do a request to abandon them. And that can be done at any time, whether before or after grant.
Thank you, Jo. That's useful. So Jo, if we spoke about the regional 2 systems, what about national filings? Is that something that you recommend? How does that work in Africa?
Sure. Yeah, I mean, so obviously the regional systems, other than OAPI, where you are not able to file directly, each of those countries has basically given up their IP legislation locally and has kind of surrendered, if you like, to OAPI. But in the case of ARIPO, other than filing an ARIPO application, one could obviously also file directly into those countries. And in some instances, our clients will do that. Some of the registries are efficient and responsive, like Kenya and Ghana, Uganda. And so we find that in some instances, a direct filing does work. But we have found in the sort of majority of cases that from a cost perspective and also from a logistical perspective, filing in any of the ARIPO member countries is actually better to be done through ARIPO rather than directly. Having said that, obviously the problem is then that not every country in Africa is a member of one of those 2 treaties, and there are some very important territories that are not members. So obviously, as we're in South Africa, I can say South Africa is an important territory that is unfortunately not a member of either of those treaties. Another very important territory in Africa is Nigeria, and Nigeria is also not a member. And then a number of the North African countries that are quite important, and we see a lot of our clients looking to file in, would be Morocco, Tunisia, Egypt, and Algeria. They're not members of any of the regional systems either. So obviously in that instance, it's important to then file directly into those territories to be able to get protection. The other thing that is important to note is, or can be useful for a client, is that in the case of Morocco and Tunisia, these are actually, they've basically acceded to the European Patent Convention. So if you get a granted European patent, you can choose to validate in Morocco and or Tunisia, which basically means your rights in Europe will extend to those countries. So that can be quite useful as an extension. I think some of the examples of clients that have looked at these sorts of filings, what they would typically do is we have a number of multinationals, particularly in the oil and gas, the mining, and the construction industry, that have done these really big sort of pan-African filings. And they would typically go into the 2 regional systems. They would designate all 20 countries in ARIPO. And then they would typically look at South Africa, Nigeria, and possibly also some of those North African countries. But the other thing, of course, which Ilse did allude to, is that there is some uncertainty in certain states, certain countries in Africa with respect to the possibility of filing, where, for example, there could be civil unrest, or perhaps the IP systems are not actually functioning. And in those countries, it's not possible to file patents at the moment. And so those countries would be Somalia, Somaliland, South Sudan, Eritrea, and Western Sahara. So there are some restrictions, but what we have done successfully for some of our clients in those territories is we have filed cautionary notices, which is basically a notice that gets published in the local newspaper in that territory. And it sets out what the intellectual property rights are that you are claiming as yours, what your proprietary rights are. And although there is no, obviously, registration, and it doesn't have the same legal force as a registration, it can be quite useful in any future litigation should the other side try to say, oh, well, they didn't know that there were any of these rights that you were claiming. So that can be quite a useful system. And then finally, I think the only other thing that's worth noting in terms of some of these countries is that although most of the African countries are members of the PCT, the Patent Cooperation Treaty, which is that international system you spoke about, this is basically, just to kind of take a step backwards, it's a system where you file one application through WIPO, and that then gives you an additional 18 or 19 months, depending on the member state, to file what we call a national phase application in that country. So most African countries are members of the PCT, but two notably are not. The one is Ethiopia, and the other one is the Democratic Republic of the Congo. And what that means is that you can't file a PCT application and then 19 months later rely on that filing to file in Ethiopia and the DRC. You would have to file directly in those states. What is useful, though, is that happily, those states have something called a patent of importation or a patent of introduction. And what that means is that if you have a granted patent anywhere else in the world, you can use that system in Ethiopia and the Democratic Republic of Congo to file a corresponding patent, and you will get a granted patent on the back of that other granted patent. And so we have some clients that have used that quite successfully. Thanks, Waldo.
No, thank you, Jo. Maybe just for the audience, so WIPO is the World Intellectual Property Organization. That's the organization that manages the PCT. Is that correct, Jo?
Yeah.
Yep. And I just want to sort of explain again why that system is so important. Quite often a client would identify an invention, speak to Jo. She will help them to say, listen, this is actually patentable. Let's explore it. Go through that process. Get to the point where you say, well, now we think we've got something that's novel, it's applicable in industry, all of those things, we can file a patent. But they don't know if this is going to be the silver bullet or the cure for cancer or whatever it may be. And you need to be careful in how you then invest in that protection. So by filing this PCT application, you are buying yourself this 18-month period in which to then further consider the commercial applicability and viability of that invention in industry. It's actually immensely important in that planning and strategic sort of steps in how do I take this potentially useful invention to something that I have now invested in extensive protection and the monopoly that is going to give me that competitive advantage in the market. So that system is critically important. And Jo, what I'm hearing from you, like with Ilse, is actually you need to know your stuff around the different options of filing, where to go, what system to use, and build that into your protection strategy to ensure that it's not only affordable, but it's effective, ultimately in its enforcement and all of those steps as well.
Yeah, and Waldo, just to kind of go back to WIPO and the PCT system, I think apart from the fact that you get this period of time, it also provides for an examination step, so that you have an examiner, usually from, one of the big patent offices that you choose, could be Europe, could be USA, and they will examine your invention to see whether it in fact is patentable or not, and they will give you a report. And you have an opportunity during that phase to sort of respond and make any amendments that might need to be made. And if you get to a point during that international phase where you have an examiner who's happy with your claims, that can be very beneficial going forward, because a number of the patent offices in other countries will actually consider what the examiner has said. And although it's not binding, they can often be persuaded by what the examiner has said. Now, there are obviously countries like America that are going to go and do their own thorough examination and aren't necessarily going to take that into account. But in the case of Africa, if you do have a good opinion that comes out of the PCT phase, that is very useful on the African continent, because in ARIPA, for example, where they do examine patent applications, they will almost inevitably consider what the international phase examiner has said, and will basically reiterate that, which you would then need to respond to. So if you've got a clear bill of health, so to speak, you will get through an ARIPA application very easily.
So Joe, to put that sort of in a sense in my own words, so what I'm hearing is that the PCT process affords me the opportunity to go to a robust examination sort of country, get a report that's going to give me a relatively good indication whether my investment in designating further countries is worth it, because it's going to identify a risk, or it's going to help me to overcome any office actions. So that's very important. And I think, Joe, what this highlights to me is the importance of discussing strategy with your patent attorney when you are looking at expanding and creating that monopoly. So Joe, if you could give us a few sort of notes or thoughts on patent applications in Africa, sort of as a few concluding thoughts, what would that be?
Yeah, I think probably just for people who are considering, or applicants who are considering filing applications in Africa, there are maybe just two cautionary notes that I'd like to give to them, just so that they can prepare and plan properly. I think the first thing is that when you get filing cost estimates from your associates, it's really important to make sure that you have a full idea of what that cost estimate entails. And the reason I say that is there are a number of African countries that require translation of the document. And so if you've got a lengthy document that you're filing and it needs to be translated, that can add significantly to the costs. So if you don't get that incorporated in your cost estimate, you could be in for a nasty surprise. And in some countries, it's actually required that that is filed at the same time as the application. Otherwise, there's a discretion available to the patent office to accept that, for example, in Rwanda. The other thing that, sorry, not Rwanda, Angola. The other thing that is that can very quickly add to the costs is things like excess page fees and excess claim fees. So if you've got more than a certain number of pages, you can end up paying per page quite a lot of additional money. And at the end of a patent is a set of claims, which basically sets out the scope of protection that you're looking for. And if you have more than 10 claims in quite a lot of the countries, you will pay excess claims fees, and that can ratchet up quite quickly too. So it's important to be completely aware of exactly what you're going in for when you get your cost estimates. And then the second thing is that a number of African countries require quite formalistic supporting documents. So they will require notarization and legalization or apostille of your powers of attorney and your assignment documents and that sort of thing. And that can be quite a time-consuming exercise. It can also be a lengthy process in that depending on the country that you're looking to file in, and depending on the consulate for that country in your country, there can be challenges. We had a recent application for Egypt, where Ethiopia, where the consulate in the applicant's country had been closed. And so to get documents apostilled became an issue. And so it's important to be aware that, you know, if you have that sort of issue, you can typically file requests for extension at the patent office for filing those supporting documents and that sort of thing. So I guess the take-home message there is just make sure that you are aware of what the formal requirements are, so that you can make sure that you deal with any of those things up front, and you're kind of not in for any nasty surprises.
Joe, thank you very much. We've spoken now about protection and protection strategies, and this brings us to a question that I personally have often received from clients looking at investing in Africa and intellectual property protection. Can IP rights be enforced effectively in Africa? Gaelyn, this is your domain by far. Are you able to speak a little bit to that question?
Hello, everybody. Waldo, yes. Me and my team, we do it on a daily basis. Whilst IP registration is relatively simple with the help of experts like Ilse and Joe, There is a misconception that effective enforcement of IP rights in Africa is either not possible or that it's difficult. Now, Africa is a large continent. It's made up of 54 countries, and the answer to your question, Waldo, differs really from country to country. Litigation can be protracted or ineffective, and legislation may be unsophisticated or even out of date in certain jurisdictions, but good progress is being made relating to the effective enforcement of IP on the continent due to efforts of rights holders, legal practitioners, and law enforcement authorities. And also, whilst there are various challenges in certain countries, our team includes specialist litigators with significant experience across Africa who can really effectively lead our clients through the process and ensure favorable outcomes. In fact, the majority of my team's work involves enforcement outside of South Africa into the rest of Africa.
So, Gaelyn, you keep mentioning your team, and I can't help to focus on that for a moment. What would you say sets your team apart from other teams doing this type of work?
So, Waldo, our aim is to offer world-class services on the continent and to make navigating legal action easy for our clients in the IP sphere. We not only manage our clients' expectations upfront with regard to things like costs, possible outcomes, and duration of enforcement action, but we provide really strategic, practical, commercial advice to our clients seeking to enforce their rights and ensure that they achieve outcomes which are commercially beneficial to the business.
Gaelyn, I must say I've been in numerous consultations with you, and that pragmatic, commercially minded approach comes through and really does provide clients with a solution that helps the business achieve its goals. And that's the one thing I think that's been excellent so far in working with you. How does your team achieve these things that you just explained? Can you maybe expand on that a little bit, please?
Sure. So upfront, we consider each case on its own merits. We bear in mind the country and its legal framework and processes in which we are seeking to enforce these IP rights. So factors to bear in mind upfront. By way of example, should formal litigation, and I'm not saying formal litigation isn't possible, we use it very often in very many countries, but should formal litigation in the form of trademark infringements, unlawful competition, passing off, or anti-counterfeit proceedings, should this litigation be costly or protracted, or should there be challenges with the IP legislation in that particular jurisdiction, alternate effective processes are considered. Depending how the infringing party is marketing its product or services, one or more of the following options can effectively remove them from the market. So these are things we will consider to help our clients depending on how the infringer is marketing its product or services. The first is social media takedowns. So infringing social media profiles or individual pages or posts can be taken down on any of the social media platforms. Domain name complaints. This can ensure either the cancellation of an infringing registered domain name or the transfer of that infringing domain name to our client. Website takedowns, so a website or an infringing page or pages of a website can be taken down. Company name objections, so an infringing company name registration can be removed from the company's register. We do very many of these. Advertising complaints, so in certain jurisdictions, reliance can be placed on advertising regulations to stop third-party use of infringing IP. And just by way of example, Waldo, we've acted in multiple African jurisdictions based on various causes of action for clients in a variety of industries. And just some of these are a worldwide hotel group, a major publishing house, golf's most well-known tournament we acted on behalf of, an old and very famous hotel in Venice, probably don't need to even give you the name there, multinational banks and insurance companies, major soccer clubs, and even a world-famous circus.
Gaelyn, sorry, I'm still thinking about the circus, but Gaelyn, sort of, when we talk to clients and sort of when clients think about this protection, what should they do to put themselves in the best possible position to be able to actually enforce their intellectual property and their trademarks?
That's a good question, Waldo, because it's wise to have done some backup work before coming to us. So hopefully the clients have these steps in place before coming to us to enforce their rights on the continent. So first and foremost, and I can't stress this enough, they should secure an enforceable right by registering their relevant trademarks, as Ilse mentioned, and Ilse assists with that, in the relevant jurisdictions. And when I say in the relevant jurisdictions, I don't only mean the jurisdictions in which that brand will be used or is used, but also potentially registering their trademarks defensively in the problematic jurisdictions mentioned by Ilse, or also in the jurisdictions, for example, where litigation is protracted or costly without a registration. They should also record their registered trademarks with customs in the countries in which this is possible to prevent counterfeit goods entering the country. Where customs recordals are not possible, they should approach customs informally, and this is something we do for our clients. We approach customs informally to facilitate brand identification training, to ensure that customs authorities keep an eye out for infringing products and inform the brand owner. And lastly, they should, and importantly, and this is something we also assist our clients with proactively, they should develop a trademark watching strategy. So put in place a watching service to be alerted when third parties are using or attempting to register our clients' trademark rights.
So Gaelyn, we've got about 5 minutes left. So I want to ask you this. If a client comes to me again and say, can you enforce IP in Africa? How are we responding to that?
We most certainly can enforce with the correct specialist guidance and advice, but get your IP registered to facilitate quicker, cheaper enforcement and favorable outcomes.
Gaelyn, thank you very much. To me, it gives me a lot of reassurance that sort of not only is it possible to enforce these rights, and we've got people like you thinking about this in a lateral way, sort of with a broad range of options, that investment in protection is something that can be enforced and protected. Before I conclude, Gaelyn, sort of, was there one or two things maybe that you wanted to add to the discussion?
There actually was. Thanks, Waldo. So I wanted to just tell a very short tale about a major Australian retailer that ENS Africa literally brought onto the continent. So it started off with a trademark filing project, so registering their trademarks across the continent. And it's moved on to ENS Africa, providing that retailer with tax advice across the continent. We drafted their employment contracts, their lease agreements, we set up their company structures, and so essentially the full spectrum of legal services across the continent for a single retailer. It started off as an IP instruction, but really just goes to show the benefit, I guess, of using a one-stop shop for legal services across the continent.
Thank you, Gaelyn. That's excellent. And thanks for sharing that with us. So by way of conclusion, to bring the discussion we've had today to a close, I want to refer back to the African Development Bank's Outlook for Africa in 2023 and 2024, and just remind the audience about that sort of projected sort of position where more than 22 countries are expected to grow at more than 5%. If we then think about sort of the research done by Ocean Tomo and that concept of S&P 500 companies and more than 90% of their value being represented by their intellectual property assets, it really leads us to the point where we need to appreciate that any kind of investment in Africa or expansion or entry must go hand in hand with a comprehensive process of identification and protection of intellectual property assets. And the one thing that I know that this team does exceptionally well is looking at enforcement and the creation of value as the outcome that you want to achieve when you make that investment in intellectual property assets. So with that as a conclusion, thank you very much, everyone from the intellectual property team side. Celia, back to you.
Thank you, Waldo. I think that was a really interesting discussion, especially for us as non-IP lawyers. I found it fascinating, and I hope our attendees did as well. I see we have one question, and that I think is for Ilse. Ilse, the question is just with regards to our HAPI filing, must the trademark be used in all our HAPI member countries since the applicant is not able to designate specific countries?
The simple answer is no, not necessary.
Great. Thank you so much. Yeah, thank you again. And to our attendees, if you have any follow-up questions or queries, please feel free to contact any of the panelists or your key contact at ENS Africa, and they'll direct your question to the appropriate team member. Our next Investing in Africa webinar session will be in about a month's time, and we'll focus on Zambia, and you should be receiving invites to that shortly. Please look out for it. But otherwise, enjoy the rest of your day, and thank you all for joining us.
Thank you, everybody.
Thank you.
Are we all still here? I'll give you a Teams call.